Michael Popok, Legal AF, reporting from an undisclosed location in Georgia. Here to talk about, though, Jack Smith, Donald Trump's lawyers, Judge Tanya Chutkin in the District of Columbia, both sides throwing haymakers at each other in rapid pace, just hours apart, concerning the protective order motion, and the Department of Justice is digging in its heels that it needs a protective order motion to stop Donald Trump with his obvious efforts to try his case in the public by commenting inappropriately and in violation of the local rules, the local criminal rules about witnesses, evidence, his case. He doesn't have a First Amendment right, although you wouldn't know that by how John Lauro, in 5 different appearances on television, must-see TV for Jack Smith on Sunday, what he said about the case, the witnesses, what Donald Trump said about the case and witnesses, all in violation of local rules. A criminal defendant does not have a First Amendment right to go on television or social media and talk about the evidence against him, the witnesses against him, and sensitive information against him. He has the right to obtain that information. He has a right to obtain that information from the government in order for him to put on a defense in a court of law, not a court of public opinion. That is the basis for the protective order. And all John Lauro is doing is giving the government Exhibit A, B, C, and D. And how do I know that? Because in something that was just filed by the Department of Justice in the last 2 hours, it only took them 2 hours to generate 9 pages to file their reply paper to finally conclude the briefing schedule set up by Judge Chutkin about whether there will or won't be a protective order, a gag order in place, and what is the contours of that protective order. This has all been going on since Friday. Before I read from the reply paper that the government just filed, including them quoting chapter and verse as we expected on the MeidasTouch Network and Legal AF, everything that John Lauro said on television ended up being put back in his face and fired back at him in a counterpunch by the Department of Justice in their filing, right? Continuing to pay dividends. As I once said, on Friday or Saturday, when the Trump campaign or Trump himself on social media put out a viewing guide of all the appearances for John Lauro, they should have just put Jack Smith mandatory television watching guide and the rest of his team, because they were watching. That's why they don't really want to gag Donald Trump or his lawyers. They want him to continue to violate all the rules so they can fire back at them in filings. Let me just quickly catch you up as to where we are with this final piece of paper. It started on Friday. The government, triggered by Donald Trump social media posting a threat, a threat of violence against prosecutors and others. You're coming for me, I come after you, with then a picture of the fraud squad, which is all of the attorney generals and prosecutors, including Jack Smith, going after Donald Trump. The Department of Justice and the special counsel was going to file a motion for a protective order anyway, because they had a shed load, that's a legal term, they had tractor trailer loads, hundreds of terabytes of information ready on the drop of a hat, drop of a dime to turn over now that he's been, Donald Trump, indicted and arraigned and released on special conditions. They were ready to go. We know this. Jack Smith is not going to put anything in the indictment. He doesn't have 6 ways to Sundays supported by witness testimony, by evidence, by text, by emails, and the like, videos and recordings and lawyer notes for each of those paragraphs. It probably rests on 5 or 6 discrete pieces of evidence, unique pieces of evidence and witness testimony. Right? It's the indictment. The protective order is they were not going to bring this indictment, right, until they also had all of the documents ready to go and prepared to turn over to Donald Trump, subject to a judge entering a protective order. Even Judge Cannon in the Southern District of Florida for Mar-a-Lago entered a protective order. And the protective order that the Department of Justice proposed on Friday, just this past Friday, was almost identical to one that was already entered by a Republican-appointed judge, Judge Carl Nichols, in the Steve Bannon case. So they took the Steve Bannon Republican-appointed judge and they put it in front of Judge Chutkin and said, we just want the same thing. That's a good place to start. And that was on Friday. And by the way, Judge, he's threatening us. And you can see what he'll do if there's no protective order in place, quoting from that social media posting of the threat, the mob threat. And Judge Chutkin took it seriously, demonstrating also how she's going to run her courtroom, right? And the discipline at which she runs her courtroom, which comes from having been a trial lawyer, having tried 15 or 20 cases before she hit the bench, and then been on the bench for already 13, 14 years, trying hundreds and hundreds of cases successfully. That's that Judge Chutkin. So she knows what she wants. She knows how to run her courtroom. She has a firm hand on the tiller. And she said, fine, I agree with you. We need a protective order. Your protective order looks pretty good. Let's hear from the other side. This is Friday. You have until Monday at 5 o'clock to tell me what's wrong with this protective order proposed, to give me a red line of proposed changes and make any argument that you want. Donald Trump didn't want to do that. And he knew that John Lauro was going on 5 different news shows, 4 news shows and 1 Fox shows on Sunday to talk about everything that he won't be able to talk about once the protective order is in place. And so he tried to get more delay, right? Buy more time for John Lauro to be able to hit that circuit on Sunday. And so he said, any more time, Judge? Money doesn't work for us. How about Thursday? Thursday's pretty good for us, and we can get together over a cup of coffee and have a conversation. I mean, I'm giving you the summary of their motion for enlargement of time. And the judge fired back right after that within like an hour or 2 and said, I don't know what part of Monday 5 o'clock you didn't get, but you have till Monday 5 o'clock. You want to use that time, you can do whatever you like. You can do a red line, you can give me a piece of paper, you can propose your own thing. I don't know about a hearing. I'm not sure I need one, but Monday 5 o'clock. And Monday 5 o'clock came, and 14 pages plus an attachment later, Donald Trump and his counsel, John Lauro, John Lauro, because Todd Blanche isn't yet admitted into the D.C. court to be able to make an argument. Let me repeat that. He's still pending a motion to be admitted into court. So Lauro has to make all the statements in the filing. And in that filing, they basically, I'll just give you a quick. They basically say, this is a First Amendment trial. It's not. And Donald Trump's First Amendment rights are being violated. They aren't. And we want to be able to use everything that's in the pile except for grand jury material. That's inappropriate. And comment on it. We don't want to have to ask the permission of the government. The government should tell us which documents they think are sensitive and which aren't, and make it easier on us. And by the way, Judge, it was really hard to file by Monday at 5 o'clock. We should always have 14 days, Judge. It'll always take us 14 days or 7 days or whatever the rule provides. And they complained about that in a long footnote, like anybody cared about that. It's just talking points for all of their new pitch about Donald Trump has First Amendment rights. What they completely ignored is that there is a local rule that deals with what a lawyer can say about a pending case out of court and out of court statements. And that local rule does not allow John Lauro to do what he did on Sunday. So he's already violated the local rule, because you're not allowed to comment on witnesses and testimony and evidence in out-of-court statements. You can do whatever you want in the courtroom, but you can't go on television and do it. And that is a violation of a local rule, which I'm going to show you in a minute. And then Donald Trump, of course, continued to attack Mike Pence and other potential witnesses, only reinforcing the argument that the government made in its first filing for the motion for protective order on Friday, that Donald Trump can't be trusted. He needs to be gagged and shut down, Judge. And let's use as examples things that happened over this weekend. And that's exactly what the government did. They hoisted Donald Trump and John Lauro on their own petard and used as their own examples things they did over the weekend. And I'm going to read from the filing that just happened for those that are playing the Donald Trump on trial home game, docket entry number 15. And in docket entry number 15, the government started with, the central purpose of criminal discovery is to provide the defendant with materials necessary to prepare for a fair trial. To facilitate the efficient production of discovery to the defense, the government proposed a reasonable protective order consistent with the current practice in this district. The defendant instead proposed an order designed to allow him to try this case and in the media rather than in the courtroom. Right? You have a constitutional right to a fair trial in a courtroom, not to be able to go tit for tat or in the public domain and go on every news show and every social media platform and crow about your case. The government went on to say, to safeguard witness privacy and the integrity, there's a word you don't often hear associated with Donald Trump, the integrity of these proceedings, the court should enter the government's proposed order. And then they said in their argument, and this is again quoting from the government, the defendant's proposed order would lead to the public dissemination of discovery material. That's a no-no. Indeed, that is the defendant's stated goal. The defendant, Trump, seeks to use the discovery material to litigate this case in the media, but that is contrary to the purposes of criminal discovery, which is to afford defendants the ability to prepare for and mount a defense in court, not to wage a media campaign. The court should instead enter the government's proposed order. They then quoted from Trump bashing Pence just this past weekend in footnote 1. The defendant has made a number of additional social media posts related to this case since the government filed its protective order motion on Friday. For example, the day before his counsel made comments about Mr. Pence, the defendant, Trump, posted the following to social media, quote, "Wow, it's finally happened. Little Mike Pence, a man who was about to be ousted as governor of Indiana until I came along and made him VP, has gone to the dark side. I never told a newly emboldened Pence to put me above the Constitution or that Mike was too honest. He is delusional and he wants to show he's a tough guy." But even more cutting, if you will, by the Department of Justice and Jack Smith is the quotes they make of John Lauro on television. And what they say about that, which I love, and I'm going to quote from it here, is that, as you know, I'm a trial lawyer, and when I'm not breaking down the latest legal filings of the day for you on Legal AF, I'm jumping from courthouse to meeting, and it can be exhausting and, frankly, dehydrating. That's why I started using Liquid IV. Liquid IV is the #1 powdered hydration brand in America and is now available in a sugar-free option. With 3 times the electrolytes of the leading sports drink, plus 8 vitamins and nutrients for everyday wellness, Liquid IV hydrates 2 times faster than water alone. And you can keep your daily routine exciting with 3 new flavors: white peach, green grape, and lemon lime. I love how Liquid IV makes me feel. After having Liquid IV, I feel ready to take on the day at full strength. Also, the packaging is super convenient and makes it super easy to carry with me for when I need it most. My favorite flavor is the white peach. It's robust and super satisfying, but you can't go wrong with green grape and lemon lime either. Just 1 stick of Liquid IV in 16 ounces of water hydrates you 2 times faster and more efficiently than water alone. There are no artificial sweeteners and 0 sugar, with a proprietary amino acid allulose blend for a sweet taste without the calories or raised blood glucose levels you get from sugar. And of course, it's non-GMO and free from gluten, dairy, and soy. Liquid IV believes that equitable access to clean and abundant water is the foundation of a healthier world. They partner with leading organizations to fund and foster innovative solutions that help communities protect both their water and their futures. To date, Liquid IV has donated over 39 million servings in 50-plus countries around the world. Real people, real flavor, real hydrating. Now sugar-free. Grab your Liquid IV Hydration Multiplier sugar-free in bulk nationwide at Costco, or get 20% off when you go to liquidiv.com and use code LegalAF at checkout. That's 20% off anything you order when you use promo code LegalAF at liquidiv.com. These are the 5 shows that Lauro was on, and here are quotes that the government wants Judge Chutkin to know about. And I quote from the brief. On Sunday, August 6th, defense counsel appeared on 5 television programs and discussed this case in detail, publicly commenting on topics including the parties' disagreement over the protective order, the defense's planned legal arguments, the defendant's actions and statements during the charged conspiracies, and expected testimony of prospective witnesses. For instance, on CNN, quoting John Lauro, this protective order that's being suggested by the Biden administration is an effort to keep the press from important non-sensitive information. The press and the American people in a campaign season have a right to know what the evidence is in this case, provided that the evidence is not protected otherwise. On ABC, John Lauro said, quote, "This is an attack on you and members of the press. I'm really surprised people haven't spoken out about it. What the Biden administration is trying to do is prevent the press from learning about exculpatory and helpful information, evidence that the people have a right to know. That is shocking." On NBC, he said, "Well, I'm shocked, John Lauro, and I can find you a lawyer to address this, but I'm shocked that all of the news media outlets aren't protesting what the government is trying to do. They're trying to say that we have discovery that's not sensitive, but we don't want the press to hear about it. And Mr. Trump, our team is saying, President Trump is saying that if there's evidence out there that the government has that's exculpatory or informative, the press has the right to know." Here we go. Donald Trump, the protector and defender of the press. The man who his constant harangue and refrain is that the press is the enemy of the people. This is Orwellian in its presentation, and so on. And the lawyers for the Department of Justice, Tom Windham, who signed this motion, reminded the judge, although I don't think she needs any reminding, that all of the statements made by John Lauro on all 5 news shows, or 4 news shows and Fox show, violate Local Criminal Rule 57.7b, right? Which prohibit a defense counsel from stating what he intends to do with discovery, publicizing outside of the court the details of the case and testimony of anticipated witnesses. 57.7b provides that it is the duty of an attorney in a criminal case not to publicly disseminate information or opinion, John, regarding, among other things, the existence or contents of any statements given by the accused or the identity, testimony, or credibility of prospective witnesses. So when John Lauro takes on Mike Pence and says we can't wait to cross-examine him, he just violated Local Criminal Rule 57.7b, and the government is putting them on notice. I wouldn't be surprised if we got a separate motion by Jack Smith on that local rule and the violation related to it. And for a good measure, the motion, the Department of Justice Special Counsel cites the court to a 1941 case, Bridges versus California, from the Supreme Court, which in a parenthetical quote says, "Legal trials are not like elections, to be won through the use of the meeting hall, the radio, and the newspaper." And they went on in their filing to say the goal of the defendant's proposed protective order, prejudicial publicity, is antithetical to the interests of justice. And then they reminded the judge as to why they can't accept the red lines, and she shouldn't accept the proposed changes because it just totally guts the protective order and its purpose. For instance, in paragraph 1, the Trump people want to replace certain language which would have the effect of allowing them to subpoena sensitive information through discovery and publicize it through that material. And of course, Jack Smith's group, smarter than they are, and caught that and said, well, you can't agree to that. And another interesting paragraph change, the Trump people, John Lauro, wanted to remove lawyers and paid staff for lawyers as being part of the group that can see the sensitive information, and said something like, well, there's volunteer attorneys and other consultants and other volunteers and other people that we may want to show it to. They'll all be working for the defense. And what I love this quote, the reminder from the Department of Justice to Judge Chutkin is that, remember, Judge, there are several co-conspirators. In fact, there are 6 co-conspirators who are attorneys, whom the defense might interpret as other attorneys assisting the counsel, and the court should not accept that edit. What is that catching? That means that Cheeseborough, Sidney Powell, Rudy Giuliani, Boris Epstein, John Eastman shouldn't be allowed as co-conspirators to volunteer their time and efforts and get access to all of the discovery material, especially when they're as of yet unindicted co-conspirators, but soon could be indicted co-conspirators. They shouldn't be able to get access to the very same universe of information that will be used to indict them as well, unless and until they're indicted. And so That is the attack that just shows you that for every change that Donald Trump's team made, Jack Smith saw right through it and called it out to the judge as to why this will gut and turn the protective order on its head. Now, where do we go from here, Popok? Friday started the whole thing with the filing of the protective order motion, and now on Monday, talk about wheels of justice moving fast. You can smell the smoke of the wheels of justice in Judge Tanya Chutkin's courtroom. And we have from Friday to Monday, right, with all the weekend days in between, a fully briefed motion for protective order issue, meaning we have the opening brief, the opposition brief, and the reply brief, along with some BS by Donald Trump to try to slow down the train in filings and asking for more time, 14 days every time, 14 days every time. You know what Jack Smith's team said to the footnote by Donald Trump that cried and bleated about, we needed 14 days, Your Honor. It was really hard to work over the weekend, especially when John Lauro is tied up on 5 different news shows. Please always give us 14 days, the 14 days. Don't shorten it, Judge. We always need 14 days or maybe 7 days. And you know what Jack Smith's group said? We're going to file our reply in 2 hours. 2 hours. It's like name that tune, right? Donald Trump's like, I can name that tune in 14 days. And Jack Smith's response was, I can name it in 2 hours. And they filed an 8-page brief in 2 hours. It's now fully briefed. And now Judge Chutkin has just ruled she wants a hearing. It'll be this Friday where she'll make the ultimate decision on the protective order, likely siding with the Department of Justice. Most decisions in federal court are made on the papers, meaning on the fully briefed issue. There's very few oral arguments at this level, maybe on some highfalutin constitutional issues down the road, certainly on any kind of attack on the indictment. That would be made by Donald Trump's team, but not on sort of garden variety entering a protective order. So I would be surprised, mildly surprised, if Tanya Chutkin bought in to the Trump request for the second time to have another hearing sometime this week so they can muddy the waters more with some sort of oral argument. I think she's going to rule. I think she's going to rule this week. And why I think she's going to rule this week and quickly, beginning of this week, is because on August 28th, she's already pulled everybody together in a live hearing in her courtroom in order to set the trial date of this case under the Speedy Trial Act. And she wants, I'm sure, to have cleared the brush and the undertow away and have Jack Smith's protective order in place so he can produce all the documents to the other side so they have at least the benefit of the 16 tractor trailers, whatever it's going to be, of information before the August 28th hearing. And there's going to be full briefing on that August 28th hearing that's moving on a separate track that we're going to follow in only one place, the MeidasTouch Network on YouTube, on hot takes just like this one. And so that's what's going to happen the rest of the week. We're going to follow it and everything else at the intersection of U.S. law and politics that matters. If you like these hot takes, you're going to love our long format podcast. Our long format podcast is on Wednesdays and Saturday nights. We do it on YouTube. We get 15,000, 20,000 live chatting with the hosts. Me on Wednesdays, me on Saturdays. I'm joined with Karen Friedman Agnifilo on Wednesdays. Ben Meiselas, co-founder of the MeidasTouch Network, on Saturdays. We pulled together 5 or 6 of these top stories, just like these hot takes, put it together, and we do our own version of Haymakers and Battle Royale on those podcasts. Watch it on YouTube and pick it up everywhere you get your podcasts from, including Spotify and Apple. Follow me on all things social media at MS Popok, including now on Threads. And I'll catch you on the next hot take, only on the MeidasTouch Network. Michael Popok, Legal AF reporting.
Hey Meidas Mighty, love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.